Hi, I'm Stephen Hunt, and this is Dodging Bullets, the Insolvency Practitioner's Guide to Surviving the Week. In this episode, we're going to have a bit of a general chat about our ideas and thoughts about future episodes and look back a little bit on the past episodes. I thought it'd be good just to get a feel where we're at. This is episode 9. We've got 30 or 40 episodes planned. The original remit was to really sort of focus on things that aren't debated. The debates that happen in the bar after the conference that you go to where IPs are talking about the issues that affect them. So have we achieved that, and how can we achieve it through further episodes? So just as a refresher, we've got Joe, Andy and Jane on. Frank's on holiday. And we thought we'd just chat through and see where it goes. So if I start then, just as a summary, episode 1, we started with how IPs get their work, and we all learned how to use this software. Then we moved into all things Scottish and just chatting with a Scottish lawyer about the differences between the two jurisdictions, England and Scotland. Episode 3 came in 2 parts with Matthew Letts talking about how regulators deal with certain issues, particularly mental health. And in the case, the example he had was a solicitor who was effectively suspended for having suicidal thoughts and the pros and cons of that approach. Episode 4 was working remotely, how we dealt with the issues that arose. Was it good? Was it bad? Episode 5, the jeopardy of joint appointments, built on some talk we gave a couple of years ago, where we identified lots and lots of risk issues for IPs in the joints that we take fairly commonly. Episode 6 was full and frank disclosure, focusing on a particular case with Luke Harrison and how the IP was criticised for their conduct in the case, and how much was it their fault and how much was it the lawyer's fault. Episode 7 was the balancing act, where Andy in particular and guests talked through their personal experiences of having a child with additional needs and how that impacts on professionals. And episode 8, the last one, was What Now for the Insolvency Practitioners Association, based on a recent extraordinary case that delved into my last 20 or 30 years experience of bond claims and being a successor practitioner where an IP has had their license taken away. So that's a brief summary. Over to you guys. Do you want to talk about any of those, or do you want to talk about what ideas you've got for episodes or whatever? The floor is open. Andy.
I had a couple of sort of short observations and comments on some of the previous ones we've done. I was very much interested when we did episode 6, the Full and Frank, because it was a case that's emblematic of what often happens in litigation for IPs, which is that something goes wrong and the judgment spends its entire time saying what the IP has done wrong and everything that the IP has done and how they've been bad. And it was interesting to explore how much of the, for want of a better word, blame there may lie with the lawyer as opposed to just the IP. Because, and we've had it as well previously, where it's the IP who's the person bringing the claim. So in the judgment, you tend to get all of the criticism is aimed at that person, even though you are largely reliant on your lawyers for how you conduct the litigation and for where you are doing things to guide you to make sure you do it correctly. And my other comment was related to the last podcast that we did, which was the IPA and the case of Nicholson v IPA. And it's just I still struggle to get my head around how the regulator got itself into that position. Yeah, you made the point on the podcast, Steve, that the approach of the IPA, whereby they did not want to assign the rights to be able to sue under the bond and would rather that there was an agreement between the bond issuer and the successor practitioner, such that all that happens is it all gets agreed, given the costs potentially of litigation and investigation. One can perfectly understand why they would, at the very least, not want to assign until after some form of mediation or ADR has been attempted. But then to stand in the way of the successor practitioner who is acting on behalf of that estate and to then go into bat in court against them and all of the risks that entails, I just struggle to see quite how they got there, other than perhaps by tiny steps, and suddenly you don't realize how far you've come.
Well, I think that might be an interesting episode I mean, there's lots you could say about regulation, but maybe get some IPs on who've had complaints, experiences of tribunals. IPs have lost their licenses. That would be a good one. If there's any former IPs, because the information is public, they might want to set out their case, their experience of the process. That would be certainly an extraordinary episode to record. I don't know if there's any volunteers. I can think of one or two who might talk. We could maybe approach that. But yeah, the issue of regulation, I think it's slightly unusual. I remember many years ago, people described regulation of insolvency as like having a comprehensive school with 5 headmasters, where you have the Institute of Chartered Accountants, the IPA, the ACCA, Institute of Scotland, Northern Ireland, the Law Society regulated for a while, bits and pieces of it. The Insolvency Service were also issuing licenses. And you had this mess. And there was always the debate of should you have a single regulator for effectively so few IPs, 1,000 practicing IPs and a handful of, I think it's less than 100 insolvency firms nationwide. Yes, we could take it further. We could talk about that.
I would be very interested in that because I still have, I have been recently looking at some of the regulatory outcomes for insolvency practitioners, and I have a burning question which now runs, which is, what is a reprimand and what does it do? And how bad is a severe reprimand? Having seen in one instance, someone managed to get 3 severe reprimands in one report on their conduct, and that almost every reprimand issued by one of the regulators last year was a severe reprimand. I would just love to be able to get into the details as to exactly what that is and how that interplays into licensing.
Matthew Letts has taken his point a bit further. He was posting about a Jones Day partner who was convicted, I think, of criminal contempt, who got a 2-year suspension on their license, and comparing and contrasting what happens to, say, trainee solicitors who fabricate a document. And I think the interesting thing is in insolvency regulation, you can see discussions between IPs where they are able to distinguish between the regulator. So the IPA is seen more lax than the Institute. The Institute of England and Wales. The Institute in Scotland, I think members generally say that they're keen to fine quite regularly on lots of different minor points. But the fact that you can choose who your regulator is, and you can choose, so effectively you choose which suits your position on default, I suppose, your own misdemeanours, who issues the most reprimands, that's certainly worthy of debate.
And just jumping in there, I thought it was really interesting that on that point that, Steve, I think you mentioned in the podcast that the Insolvency Service, what questions will they be asking? In a way, you've got a sort of a quasi-regulator regulating another regulator. It's sort of, it's a strange one, isn't it? You've got all of these different quasi-regulatory bodies who are looking at the same picture. I'd be very interested to see what the Insolvency Service say in response to this.
The history, the IPA sprang from effectively being a trade body for the insolvency profession in the 60s, I believe. And then when licensing came out in 86, it applied to also be a licenser. And that caused, obviously, a difficulty in being both the trade body and the regulator, something I think the legal profession has debated. And so the Society of Practitioners of Insolvency was formed, which became R3 at the end of the 90s. The path of which the Institute is simply as an experienced regulator of accountants, and many IPs were accountants. So why not regulate IPs? Ditto lawyers and so on. So even their path to becoming the regulator is slightly different. They have their own biases. So the Institute in England is a big, massive organisation, relatively well funded compared with historically the IPA. So it would treat IPs as you would treat accountants, whereas the IPA only regulates IPs. And so the character of its regulation will be different. They've now consolidated. The Insolvency Service no longer licenses. The Law Society no longer licenses. The ACCA, I think, subcontracts to the IPA its inspections. Maybe we should have an inspector on. It'd be good. Maybe get someone from the IPA on in the next few months to talk about the inspection regime, or ex-IPA staff. Just talk about the differences and what steps are taken to make those differences very small, or do they actively promote their differences? That'll be interesting. What else have we got? What else can we talk about? because I don't want to focus all on regulation. Jo?
I think a good subject to cover would be charities, because at the moment in the current climate, people are relying on more and more on charities, but the charities are also subject to the current climate and the increasing costs. And I've noticed in the Gazette quite a few charities cropping up where they've gone into administration or other insolvency.
Fine, but I think we'd have to consider that the primary remit of this podcast is to look at it from the IP's point of view. So can we think of any alternative or issue for the IP in dealing with charities that isn't present in other cases? Or should we explore that and find out if there are?
I think, yes, from a sort of point of view of an IP, I think looking at the charities, is it just the rising costs, or, are the small charities going into insolvency processes because of the way that they've been run?
Well, there's the PR first. Just when you're an IP liquidator of a charity, we've seen the Batman Jelly case where
just going to say that.
Yes, the Batman Jelly case. There's a high level of public interest in that. I've certainly liquidated a few charities, and if you start suing trustees, some of whom may be well known in other areas. They may be what they would describe as non-executive. They may have quite different approaches to what we describe as corporate responsibility. And are you going to scare away potential good intent by trustees by focusing on litigating against them? That's a PR issue, I think, at the absolute minimum. Here's another one. What about some top 10s? Top 10 frauds that you find? Top 10 examples of misfeasances. We could probably go back into some of our cases and talk to some other IPs on the show about what they see the most of. Maybe in a particular industry, you could probably break down the vehicle of a top 10 into quite a few subcategories. Yeah, top 10 defences, top 10 causes for reprimands to IPs to get back to regulation. Andy?
I was going to go with top 10 tips to make sure your quad goes as smoothly as possible.
Be lucky. Jane?
Yeah, I've just been looking at director disqualifications and the changes since COVID, given that we've just had the 6-year anniversary since the first COVID lockdown in March 20. And that was, of course, when the financial assistance started to be given to businesses who were impacted by COVID. We all know that businesses receive bounce-back loans, some of them fraudulently, which led to the Insolvency Service bringing hundreds or probably thousands of claims against directors for misconduct, which in turn led to disqualification. So 6 years on, I'm interested to see that the Insolvency Service really still is bringing a huge number of claims for COVID loan abuse. But how does that compare with others of claim pre-COVID? So trading to the detriment of the Crown, wrongful trading, that kind of thing. Presumably those claims are still out there, which made me start thinking, well, are IPs, are they not reporting those? Are they purposefully focusing on the COVID loan abuse? I know some IPs think that Insolvency Service goes for sort of risk-averse, low-hanging fruit COVID misconduct cases, but, do the stats bear that out? And looking forward, are we moving away from, we're going to have to move away from COVID loan abuse at some point? What does the future landscape look like?
Certainly, where I opened by talking about the things that IPs discuss in the bar at conferences, that disqual point, the low-hanging fruit is quite a common one. I think it's been fascinating for me to see how much has been thrown into the bounce-back loan stuff, and you can understand sort of the IP point of view that they might be reporting much larger amounts of fraud, losses, misfeasance that don't get picked up, but every small bounce-back loan does, and then I think some IPs have actually been fined for failing to do disqualification reports about bounce-back loans. So whilst you should obviously obey the rules and obey the initiatives, I can't help but thinking, but the experienced IP is sitting there thinking, aren't I really just participating in a statistical scheme to try and up the numbers by the government, and we're not really solving the ongoing problems? But the bounce-back situation was a sort of one-off. You couldn't do wrongful trading, for example, for that period. but take out a £50,000 bounce back loan and you can be pursued. The £1 million wrongful trading, no chance. It does feel a little bit perverse with hindsight.
Yeah, and I think that's right. I mean, let's look back before COVID, and I was involved in director disqualifications. A director, taking 50k from the company for personal use. I mean, it would have been frowned. Would it have got an 8-year mid-bracket disqualification? I would be surprised. Are we now sort of in, or have we now been in the situation where public interest is key? It's public money. Have we gone too far down that route? So what does it look like going forward as the bounce back loan abuse disappears? Are we going to get sort of back to normal, business back to normal, HMRC cases and that kind of thing? I'm really interested to explore that a bit more.
This is where everything plays into my geeky nature, because I had a lot of these thoughts a month or two ago. And so I have spent some time perusing the stats and reports that come out from the Insolvency Service on the disqualification outcomes. And largely speaking, lots of what you are suspecting is borne out by the stats. I won't go through it too much here because it would probably take over the entirety of this podcast, but I'm sure we can fit in the next week or so to record something going through, because I looked through, first of all, the percentage of the cases that were brought as to whether they related to bounce back and CBILS as opposed to other types of misconduct leading to disqualification. And then I also looked at how long the disqualification periods were for each of the categories compared to the amount of money involved. So, for example, someone getting 10k for a DK bounce back loan compared to, there was one article where I think someone moved something like, it's either 8 or 32 million euros out of the country, and they still only got about 9 years. And so that's what caused me to look.
I'm going to interrupt you there because you are going to geek out. But also, I think, yes, let's do one of those. Who would you have on the show? Who would you have on the episode in an ideal world to debate those issues?
I think it would be a lawyer. I'm a lawyer, so it'd be quite good to get another lawyer on.
I would love to hear from someone at the Insolvency Service, not for a combative discussion, but just to understand a little more on their approach as to how they view these things, and possibly how much, whether they would admit it, how much of this seemingly targeting of bounce back loans is political. Maybe the head of policy. We could have a chat. I know Paul, and see if we can get him on. A defence lawyer would be good, actually, talking about. I think it'd be good to get the balance. Let's move on to another one. Other ideas? Any other bits and pieces? I'm going to chuck another one in. It's almost booked, which is looking at how IPs are portrayed in the media. We've done in one of our physical conferences things. We looked at a Times journalist looking at how our stories are portrayed. I'm interested in how IPs are portrayed in fiction, because most people don't understand what we do. At least of all our families, in many cases. And so having the task of maybe writing or in a soap or something like where insolvency, bankruptcy comes up, how do they approach it? That'd be a fascinating subject to maybe get a few examples of that on. And you get a completely outside perspective from the arts on what they think of our profession. I remember an anecdote from, must be 23 plus years ago, when I was at the Official Receiver's Office still, where I think in EastEnders, Ian Beale went bankrupt, and the writers from EastEnders reached out to the Insolvency Service to find out what bankruptcy entailed. And the telling from I think it was an AOR, was that they found that was too boring, so just ignored everything the Official Receiver had told them and made up what they wanted to do so it looked good on TV. I remember the character of the IP was an absolute spiv. He was seedy and casual and completely unprofessional. So it's the Insolvency Service's fault, is it? Is that what we're saying? But no, if we can find the writer of that episode, let's get them on. That'd be great fun. Well, for us. Any other topics? Any other thoughts? I still find myself pondering the fallout of the Zedra case and limitation, and exactly how far that reaches into insolvency. There was quite a large sort of amount of discussion, particularly on LinkedIn, amongst lawyers about the impact of it, and everyone trying to work out exactly what really is a surety or not. And the fact that what has been explicitly sort of changed in the law by the Supreme Court, what's been suggestively changed in that it would appear that if those claims came before the Supreme Court, they would overrule what the previous Court of Appeal rulings were. And then there are other types of claims that weren't mentioned or weren't really dealt with in there, and how far they go. And it's the sort of thing where I feel like I've got to write down my thoughts at some point properly to really get into the nuts and bolts. Because in truth, going by the legal teachings, the ratio of that judgment only impacts on unfair prejudice petitions. But in doing so, the Supreme Court has explicitly said that the judgments in relation to 423 and to 238, 239 were decided wrongly. So that would suggest they've been changed, but technically they haven't.
I think maybe inspired by Zedra, what we could do is an episode about practical issues of limitation on investigation. So just rehearsing the sort of Eurocruit case, the item software versus Fasihi, line of authority, section 21, section 32 limitation, and then looking at practical things of Leitch's, particularly as one of the consequences, Zedra, assuming that it goes the way people think, is that there's a potential upside by saying, hey, we're no longer restricted to 6 years to bring these claims. When it steps outside the Limitation Act, understanding the alternatives, remedies and equity of delay means you could have less than 6 years to bring these claims. So it's not necessarily of benefit to the IP to have these things taken away, which takes you on to the practical issues of how stale is a stale claim, how would the courts approach claims where you might have taken 5.5 years to investigate, got it in perfectly apple pie order, and then brought your claim. Certainly we've got experience in that in court in things like fraudulent trading. And some of those are still ongoing. I think overnight in particular, where I chose to wait 5 3/4 years before issuing a claim, and the director made an application saying that was inherently unfair because he'd acquired assets in the meantime, so it was in the interests of the estate for me to bring the claim then. So we've got quite a lot to say on those points, and it's pretty worthwhile having a look at all of that in an episode or two, I think. Another topic brought up I thought was quite interesting, inspired by the recent Sheffield Wednesday case, is what if you have an overbidder? What if someone bids way more than anybody else to the point where you don't think the bid is serious? I think it's more inspired by than actual. I don't know enough about the Sheffield Wednesday case, but I've certainly had cases where you've had bids for extraordinary amounts. Are they shut-out bids? Then they're going to try and chip the price down at the last minute, which is a concern for the IP. Or are they just fake? Are they just kicking tires? Or do they actually occasionally come through? Again, it might be a case where we find some IPs have got experiences one way or the other, and having a chat about that.
And even if they do come through, there's then the potential, is this money laundering? Because it's one of the prime things you get in your annual training of people suddenly offering you way too much for assets. Could be that they're thinking, great, I can buy this, launder some money, and off I go.
Yeah, I like that.
I think a lot of cases, if the bid is higher, it's engineered, and I mean, it normally involves deferred consideration, which obviously doesn't get paid along the lines, and you end up turning down, or you could end up turning down a bid where, you would have got the funds in. Instead, you're going to the expense of chasing a bid to try and collect in deferred consideration.
Without going into detail, I can remember a case many, many years ago where I specifically said that I would not accept a bid from the directors, even if it was the highest bid, because in my investigation into the case, there had been financial impropriety, and it was relating to a company where, in the course of business, it would hold large amounts of third-party deposits, and they had interfered with those deposits. So I did not feel it was conscionable of me to sell them a business back, which would put the third-party money in their hands again. So that's a consideration. So maybe we'll pile that into an episode as well.
I think it's just a sniff test, isn't it, on a lot of these things where you just know there's something wrong there. It's too high or it's too quick. The investors can really dig out some extraordinary wheezers. But
if they pay, is it my duty? It's a bit like the chat. It's almost crossing into the pre-pack area where a pre-pack is off back to the directors is often the highest bid. But ethically, morally, and otherwise, should you let them have it? It's been a debate for 20 years. One last one I wanted to look at is taking the podcast a bit further. I'd like to get on the road and have some debates with real people in the room. I think it's a great idea to get around some of the cities, talk about these issues, get issues from people in the room, IPs and lawyers in particular, and use that to generate future episodes. Not necessarily have a live episode there, but it'd be a great way of just having a chat about what's the conversation. Our profession's at its best when we're debating real issues that we face. There'll be issues around the country, regional issues as well as national issues that maybe we're just not privy to, we're not seeing, and it'd be worthwhile effectively reversing it, getting the bar talk out into the main arena, getting people just chatting, see where it goes. That'd be a very useful way of just developing whatever this podcast is going to be. Good. Right. Okay. Well, with that, let's end the podcast. That was episode 9, and see you next week.